All right. So I made a folder of some of the listing agreements that we'll normally use in a transaction. And if you notice here at the top, I actually have 3 different residential listing agreements. Okay. And I'm going to tell you the difference, the ones that we would normally use. Now, here's another little trick I'm going to show you guys. And if you don't mind, everybody, I'm just going to mute you all. And just remember to unmute yourself if you have questions. If you ever can't quite remember which forms to use, when you open the forms picker here, all forms, and it gives me the list of all the different forms that I can use. You notice the very first couple here have a period right before, right at the beginning, right? There's a period cover sheet, period residential listing agreement, period residential purchase agreement. CAR did that for us so that the forms that we use the most always stay at the top of the list, because otherwise you're trying to dig through the forms that are just buried in here. There's a ton of them, as you can see. So those are your most used forms, and the residential listing agreement exclusive is the first one. So what is the difference between the exclusive, the open, and the seller reserved? Okay, well, I'll tell you, it's pretty simple. It mostly has to do with compensation. Okay, so I'm going to open the residential listing agreement open, and I'm going to show you what I mean. When I open this form and go past our first required disclosure documents and get to the actual listing agreement, right? And again, here it says open. And I scroll down to the bottom here, paragraph G. This paragraph doesn't exist on the exclusive listing agreement. It's only on this open one and the seller reserved. And it says here, this is a non-exclusive agency listing. Seller reserves the right to sell the property either directly to a purchaser or through another broker without any obligation to pay compensation to the broker unless otherwise specified. So this is an open listing agreement. It protects your commission, but it's limited. The protection is limited. And what that means is it's limited to basically other brokers, or the seller can sell directly to a buyer themselves. Okay. So that is the open listing. It means anyone can still bring a buyer. Any buyer can buy this property directly and you would not get paid. Okay. But if you bring a buyer, then you would get paid. So that is something to be aware of. Okay. Now let's take a look at the seller reserved. So this is the second type of listing agreement we have. And again, it's going to have that paragraph G. Let's see what it says on this one right here. It says, this is an exclusive agency listing. Seller reserves the right to sell the property directly to a purchaser without any obligation to pay compensation. So this one differs in that the seller can procure their own buyer, right? So if they find their own buyer and you've used this listing agreement, you would no longer be entitled to any compensation. So that's the seller reserved. It means the seller can't work with any other agents or brokers, but they can sell directly to a purchaser. Okay. So that is the second of our listing agreements. And that brings us to the one we use the most, the residential exclusive. This is the one you're mostly going to use. Again, we have our additional disclosures, which I usually review these in the purchase agreement classes. So I'm not going to go through the agency or the fair housing and discrimination advisory. We'll look at those another time. Or the PRBS or the wire fraud. Boy, there's a lot of those little advisories and disclosures, isn't there? Finally, we get to our contract. It's interesting. The listing agreement's 5 pages. We've got like another, 9 pages of disclosures and advisories. It's like 16 plus pages. At the end of this year, guys and gals, at the end of 2021 in December, they're coming out with a new purchase agreement, and it's 16 pages. It's only 10 right now, not including the other disclosures and advisories. So guess what? We'll be having a lot more classes later on. Okay. I have a question in the chat. Do the open and seller reserve listings occur often? I would say generally, very rarely. Very rarely. I don't encourage using any of those forms unless you have a seller that's like, look, you can take the listing, but if I find my own buyer, I'm going to sell it to them and I'm not going to pay you anything. Cool. Well, we got a listing agreement for that. So, Andrea, thank you for the question. To answer it, no, not very common, but I did want to just show you that they exist in here. We're not going to break them down too much. Okay, we are in our RLA, Residential Listing Agreement, exclusive. Date prepared at the top. What is date prepared? Well, just as a reminder, that just means the day you're drafting the agreement. It's not the start date of the contract. Okay, so maybe you're taking a listing Saturday, but you're in here writing it up today. CAR puts a date field in there so they know when you were putting this thing together, prior to the actual beginning of the contract. The reason why is things can change from the time you draft an agreement to the time the agreement actually starts. Okay, I always recommend go back and review everything before you just send a listing agreement out, obviously, right? So what do we got here? Well, exclusive right to sell. We've got our seller name. We have us, they hereby employ and grant Keller Williams as the broker. And then we have our beginning and we have our expiration dates. The beginning date is the day that you have been hired. It's the day you're authorized to fulfill the terms of this agreement, meaning sell the property, do your marketing, whatever means you use to market your property, okay? That's the first day you are authorized to market the property. And we'll talk about marketing and exclusions and all that stuff when we get to that paragraph. And then we have an expiration date, okay? That's how long your agreement is for. That's how long you are hired to do your job. We generally recommend about a 6-month window. If and when we move into more of a buyer's market as opposed to a seller's market, you may start taking longer listing agreements. If you have a probate, if you have some other challenging listing that may not sell within a 6-month time frame, you may want to consider taking a longer listing agreement, okay? You must have a beginning and expiration date on your listings. If you don't, it's a violation of the Code of Ethics with the National Association of Realtors. You don't have an enforceable agreement. Your seller cannot pay you a commission, right? And the Business and Professions Code of the state of California says by not putting an expiration date on your listings, that's grounds to lose your real estate license. Okay, so the state believes by having an open contract, open-ended, that's egregious enough of a violation to revoke your license. Okay, so make sure you've got your dates on your contract. Extremely important. Next paragraph or next part of this, we are identifying the property. Okay, address. We've got our city, we've got our county, we've got our zip code, we've got our parcel number, which we can find in the tax record, and boom, there we go. There's a couple of check boxes here for manufactured home, probate, conservatorship, guardianship, in which case, if that is the case, we would attach additional documents, some advisories or addendums, like a probate listing addendum would be added if it's a probate, okay? Paragraph 2 is our listing price and terms. So here's where we will put in our price. All you do is type it in. Zip Forms will spell it out. And then maybe you have some additional terms in there. Maybe you have a variable commission rate depending on if you find the buyer or they find the buyer, or maybe you base it on getting a certain amount of price or higher, you get an extra commission or something like that. Okay. And that's that. And then we get to paragraph 3, compensation. I know it's all of your favorite part. This is where we get paid, right? So it notes here, the amount or rate of real estate commissions is not fixed by law. They're set by each broker individually and may be negotiable between the seller and the broker. Okay, so the state of California mandates that this paragraph be in bold and this type or this font size for the seller to know. They need to be aware that it is fully negotiable. Paragraph A is where we'll put in the amount of compensation. If I have a percentage, I'll check this box. I'll put in my whatever commission that is, my 6%. If it's a flat fee, you would check the box below and you would type in the dollar amount. Okay. And then there's a section for and maybe there's some additional compensation terms or what have you. Maybe it's 5% plus $2,000 or something like that. Okay. And it just goes on to state that as long as we procure a buyer who's ready, willing, and able to buy and ends up closing, then you will get paid your commission. the remainder of this paragraph 3 here, it's all compensation, if you notice, right? And basically, it's going to talk about reasons why you might earn a commission or if you're prevented from earning a commission. So there's a few paragraphs here. The first one here, or two, it says, if within a certain amount of time frame after the end of the listing period, an expiration, or possibly a cancellation, if the seller sells within whatever time period you put, you notice I have 60 days here. If the seller sells to somebody who physically entered and was shown the property, or for whom the broker, you or any cooperating broker, submitted a written offer on the property, okay, you can still potentially be due a commission provided that you give a written notice of the names of the prospective buyers. Okay, so if your listing's about to expire and you showed it to 10 people, yourself plus other agents, you need to provide a list to the seller of all those people. So that way it prevents the seller from going back to one of these buyers that came in at an open house or at a showing and they chatted them up and said, hey, my contract expires tomorrow. Come back and I'll sell it to you for less so we don't have to pay the commission. Well, that's what this is protecting you for. Okay. Again, you must provide that written list though. So make sure you collect the names of the buyers of all of the people that are going into the property, which should be pretty easy right now because you're getting PED forms signed on all of your entrants to a listing.
Nick, question.
Go for it.
Is there a specific form that you would list all those names on? Is there a car form that, or are you just doing that on a, regular piece of paper, so to speak?
Yeah, you can just type it up I mean, if you wanted to send it on an addendum or something with blank lines on it, it doesn't really matter. There's no, it doesn't state here that there is a specific form necessary for that.
Thank you.
You can just type it up on a Word doc and, give notice and make sure you have, proof that it was sent, obviously, right? Which could be as simple as just having an email, assuming you've been conducting most of your business via email with the client. Okay.
Or the client's signature?
It'd be best to get a signature for sure.
Okay. Thanks.
You bet. And by the way, guys and gals, great question. And it makes me think about this. Everything in writing, everything always in writing. Verbal is nothing, right? There are no verbal contracts here in California. So, we're not agreeing to anything verbally. And bigger picture as well, ladies and gentlemen, make sure you always document your file. Document your file. You should have, what I do is on my notes app on my phone, I create an address for my properties, for my transactions and my listings. And I make notes of what transpires, whether it's a phone call, a text, or whatever. I document everything. And when I have a verbal conversation, whether it's with another agent, my buyer, or my seller, I always send an email recap and say, here's what we just spoke about. Please let me know if you have a different understanding of our conversation. And then you have paper trail. You always want to document and have things in writing for yourself. All right, let's keep moving. More reasons why you might get paid. Well, maybe the property is taken off the market without consent. If your seller says, I don't want to sell anymore, you're not going to go hound them and say, oh, you have to sell. You can't do that, right? They can choose not to sell their property. So we would give them consent. If there is a completion of a sale prevented by another party besides the seller, you could be owed compensation. You won't collect it until whatever dispute is settled. Maybe somebody claims they have a right to the property and files a list pendants, and your seller has to sue that person and remove the list pendants. They collect damages. Maybe they choose to sell or not at that point. You could still be entitled compensation if somebody interferes in your sale. And then we get to paragraph D here, 3D. This is where we are stating to the to the seller what our policy is for cooperating with outside brokers. So when we think about cooperating in this regard, this is the buyer's agents from different brokerages. And here we're telling the seller, hey, we're going to offer to those agents 2.5%. So we have to tell the seller how much we're giving to the other party, right? Because if I'm taking a 6% listing and I'm not going to split it 50-50, the seller needs to be aware of that. right? And you need to tell them why. All right. Paragraph E just assigns the commission through escrow, so there is no further need for any additional commission agreement. This is it. And then we get to paragraph F. This is a great talking point for you guys. You know, when you go on listing presentations, here's where you might ask a few questions, because it says here, seller represents that the seller has not previously entered into a listing agreement with another broker. Seller warrants they have no obligation to pay a commission to somebody else, right? You might want to ask, have you talked to any other agents about selling your property? Do you recall signing anything? Do you have any sort of agreements outstanding that I need to be aware of? And if so, you can exclude them here, right? You can't necessarily force them to be canceled, but you can at least exclude them from the agreement, okay? Let's see here. Let's move on to paragraph 4. So 4A, items excluded and included. Now, remember, the things that come with the property, excluded and included, that's an agreement between the buyer and the seller. Now, this is your chance to ask the seller, is there anything that is not coming with the property that would not normally be, that should normally come with the property, i.e. anything appurtenant, right, or attached to the property. So this is your chance to ask the seller, is there anything here that's sentimental, that is screwed down, that you're taking with you? Chandeliers, the drapes, plants, you know, anything that you want to let me know about. You can walk the property with your client and bring it up. And then of course, anything that's included, furniture, et cetera, whatever they're going to leave with the property. So a couple things about this. One, whatever you write in here is not an agreement with the buyer, obviously. So you need to specify on the purchase agreement any things that you're writing in here. And two, right, if you make a note of things in here and you screw up and forget to put it in the contract, well, as my attorney would say, don't forget to bring your checkbook, right? Because you're going to need to write a check to get yourself out of that one. All right. So make sure you're clear and make sure you remember when you are negotiating with the two parties. Okay. All right. Let's keep going. Paragraph 4B, leased or liened items. This is your chance to ask the client if they're aware of anything that is leased or liened or that is not owned by the seller, and it's your chance to address it, right? We see this pretty frequently with solar or what is it? Updating to dual pane windows for energy efficiency, putting in alarm systems and HVAC that may be financed or done through one of those old Hero or PACE programs. So again, all we're looking to do here is see if there is any sort of a concern or issue that needs to be addressed, because you don't want to have this come up on day 25 of your escrows and realize, oh shoot, we have a solar lease that needs to be transferred, and guess what? You're waiting 2 weeks now to get that thing transferred. Okay. Plus, you want to make sure that the buyer can take it over or the seller's going to pay it off. I mean, you want to have these discussions up front. I know it's not always possible to anticipate what the end of a deal is going to look like, but I use these agreements as prompts to remind myself, and you guys will remind yourselves of these talking points that you can bring up for your transactions to get ahead of it. You want to be way ahead of this stuff and be as foresightful as possible. Let's keep going. Paragraph 5, and in fact, the majority of the rest of this page, plus a little bit on the next, talk about MLS exclusions, what used to be called off market, which really isn't a thing anymore. Okay, it kind of is, but not in the way that it used to be. So paragraph 5 first, there's a paragraph that's defining what the MLS is. B talks about what is provided to the MLS. And then C is asking, what MLS are we a subscriber to? Well, you guys are all members of the CRMLS. Some of you may be subscribers to outside MLSs like, I don't know, Palm Springs, or the Flex MLS that is for the greater Antelope Valley for Palmdale and Lancaster. They have their own MLS. Okay. So there are outside MLSs. And what this paragraph here is talking about is, are you a member of the primary MLS? Okay. So if you are going to take a listing in Palmdale, but you are not a member, you have not joined the Greater Antelope Valley Association of Realtors and gotten access to Flex MLS, you need to check this box and let the seller know that you are not a member of the primary MLS for that property. Why? We have to tell the seller that we may not get enough exposure to that property, right? Because if it's not in the local MLS for those agents, many of them may never see it. And then all of a sudden your seller is going to come back and say, I think I could have got more money. Why didn't you tell me you weren't a member of this MLS? Okay. Pretty important. Moving on, paragraph 6. It's in a big box. That must mean it's important, right? The benefits of using the MLS, impact of opting out. So this paragraph is basically saying, hey, seller, if you don't want your property in the MLS, we need to let you know what that could mean for you. First, exposing through the MLS basically means every buyer out there is going to see the property because it's going to be available on every normal major platform. If you opt out of using the MLS, you have to understand that you're agreeing and authorizing to limit your exposure, to not market or advertise the property to the public. Okay. Hear that again. No marketing to the public. Remember, if a property is excluded from the MLS, it may not be allowed to market to the public. That is the new National Association of Realtors rule as of July 1st of last year or so. I think it was actually May 1st. In addition to that, no MLS will be pushed out to the various websites and platforms. I believe I heard our MLS attorney say that there are around 12 or 13,000 agent websites that are IDX compatible, including all of your command sites here in California. So that's a lot of different websites that get the properties. Okay. It notes your reduction in exposure. You're going to have less exposure, less marketing, limited exposure, obviously. And then also, if you don't list in the local MLS, that could reduce in a deduction in exposure. And remember, or a decline in exposure. So remember, all these paragraphs are pointing to is that when you don't have something on the open market, you may not get fair market value because the market isn't aware of the property. Okay. So that leads right into paragraph 7 with clear cooperation. Okay. Okay. Good question. Andrea asks, does that mean our sellers cannot be in contract with a buyer unless their listing is on the MLS? No, doesn't mean that necessarily. Okay. There are ways that a buyer can buy a seller's property without it going into the MLS. If you have registered the listing as excluded, you as an agent can market your listings to other agents within your office. And we have agents here from Long Beach, Cerritos, and La Mirada right now. Only your office, not between the 3 offices. Okay. Just because I'm the broker of all 3, they're separate brokerages. Okay. So you can still market your listing to agents in your office and all of your own clients and all of our agents' clients. So your agents, your associate agents in your office can tell their own clients. Now, the definition of a client for that purpose would be anyone that has signed the agency disclosure form within the past 1 year. Easy enough to get that done up front. Okay. Also, if the property is maybe in the coming soon status, a seller can still accept an offer subject to inspection, but they can't show it, but they can still accept an offer. So there's some nuances there, Andrea, and hopefully that makes sense. Let's keep going here. Paragraph 7, clear cooperation policy. MLS rules require, they do. You're not going to check the do not, obviously, here. It is required. But it says here is that residential property 1 to 4 and vacant lot will be put in the MLS within 1 business day of any public marketing. Remember, public marketing, that can cover a lot of things. That covers a social media post. That covers an email to your outside to your database. That covers a sign in the front yard. And yes, I did say an email to your database. Every single person in your database is not a client of yours. because you have a lot of people you haven't bought or sold properties with, especially in the past year. Remember, the definition of a client is somebody that has signed the agency disclosure form within the past year. What is that form, by the way? It's the very first form you would normally sign, disclosure regarding real estate agency relationships, whenever you take a listing or write an offer or even a lease listing. Okay, let's get back to where we were. I get a lot of questions about this stuff, guys and gals, and it is confusing, and that's okay because I'm only a phone call away. I will walk you through all this stuff, okay? So Clear Cooperation says property goes in the MLS within 24 hours or 1 day, 1 business day of public marketing, okay? And then it goes on to define what public marketing is. It's basically anything except for telling your own clients or the agents in our market center, and that's it, okay? Next is a paragraph on coming soon, and it basically just discusses that there is a coming soon status and the fact that it will be viewable, to the public, cannot be shown in the status of coming soon. And we're just letting them know, do you want to use that as a method to market your property? Most people or many agents will say, well, as we're prepping the home for sale, we'll put it as coming soon, get people excited about it, and then when we flip the switch and go active, then boom, we will launch back into showing the property. Okay. Paragraph D, seller instructs broker. Okay. And this is where we're going to either put the property in the MLS or to exclude the property from the MLS. When we exclude the property from the MLS, we need the SELM form, seller exclusion of listing from multiple listing service. Okay. So if they say, I am instructing you to not market the property to the public, you're going to check that box and you're going to add the SELM form and you'll fill that out appropriately, which we'll look at in a little while. Okay. Alrighty. And then it notes here, seller understands that should any public marketing of the property occur, the property listing will be submitted to the MLS within 1 business day. Okay. The other rule that's in effect, in addition to the Clear Cooperation, is that a listing must be entered into the MLS or excluded within 48 hours of you signing the beginning date of the listing agreement. So there's 2 rules that kind of overlap each other. One has to do with public marketing, boom, 1 day MLS. The other has to do anytime you take a listing, 48 hours, it must go in the MLS or it must be excluded. And excluded means actually entering it as a registered listing in the MLS. And I'll pull up the different statuses and what they mean and so on to hopefully create some clarity around this. Okay. All right. Let's keep going. That's a lot about exclusions, right? It's pretty confusing, especially when you have 2 different rules overlapping each other. All right. Paragraph 8, MLS data on the internet. Basically, it's just saying that, we're going to advertise the property. It's going to have your address. It's going to have other features that may be marketed, such as like comments, reviews, automated estimate of value or a Zestimate, those types of things. And that, we can allow you to opt out of some of those features if you choose. Although I will say you don't have a lot of control over other people's websites. So really that may not be possible. And it shares that in this paragraph actually. Okay. So I'm not going to dig too deep into that paragraph, but it is something to note. Okay. Paragraph 9, seller representations. This is where basically the seller is stating that they aren't aware of anything essentially that could prevent the property from selling, such as a notice of default, delinquencies affecting the property, bankruptcy, insolvency, litigation, arbitration, administrative action, government investigation, or pending or threatened action that could affect the property or the seller's ability to transfer it. Okay. So this is where, again, you can ask those questions. Is there anything I should know about regarding your property that could affect you being able to transfer this property? Also, by the way, probably a great time to take out the order for the prelim, right? Get your preliminary title report ordered now. That would be a good time to do so right away. I do it up front, right when I take the listing. I do not wait till we're in escrow. I want to see what's on that thing. All righty. Next is paragraph 10, broker and seller duties. There's a paragraph about your duties in the listing agreement, and there's one in the purchase agreement. And they're extremely important because it tells you what we're going to do. It tells the seller, here's what we're going to do. Okay. We're going to exercise effort and diligence to achieve the purposes of this agreement, which is to get it sold. We're going to advertise. We're going to market the property by any method and in any medium selected by the broker. Okay. We're telling them we're going to do whatever we feel necessary to sell this property unless otherwise agreed in writing. Okay. And it also notes here that the seller will disclose to any licensee making an inquiry and the receipt of offers on this property and the offering price of such, right? So it's interesting. We're given permission to tell other agents if we have offers and what the price of those offers are. I ask the question all the time, are we allowed to disclose the highest offers or the offer prices that we have? We can. We're granted the right to do so. Now, you all will use discretion in your negotiating tactics on whether you choose to do that or not. We're agreeing to present all offers when they're received, and the seller agrees to consider the offers presented and act in good faith to accomplish the sale, right? So they're agreeing to, right, walk with us through this process and get this place sold. Lastly, seller is responsible for determining at what price to list and sell the property. We're going to give them advice on whether the offers coming in are good, should be accepted, should be countered, et cetera, but ultimately the seller has that responsibility. There's a section here for investigations for basically pre-sale. And not super common, but you may choose to get a termite report up front, or sometimes I've seen people get inspections done up front. I have a listing coming up in a couple of months where it's a fixer, it's a trust sale. The seller told me that there's probably some plumbing issues, et cetera. And I'm recommending to them to get an inspection report because I know it's vacant, it's a fixer-upper, I'm just going to get a ton of activity. I'm not even going to look at offers unless they have reviewed the inspection report first, because I don't want to do the dance of this whole back and forth with repairs. It's a trust sale. The owner passed away. We want this thing sold. So I'm going to preemptively get that done to weed out, the squeamish or people that just don't see themselves doing a bunch of work on a property. So you can do pre-inspections. There's a paragraph for that there. All right, let's keep moving. The deposit, we're not really going to deal with that. Agency relationships. So we're acknowledging the disclosure regarding real estate agency relationships. We are telling the seller that we may have dual representation. We may represent the buyer and the seller, and this listing agreement authorizes us to do so. And we're also giving them the PRBS form, possible representation and consent to represent both parties. Confirmation will be done in the purchase agreement. It notes here that it'll be done at a later time and that they have received the PRBS form, which is right up front. All right. Paragraph 13 and 14, we're talking about security insurance, showings, audio and video, as you see, and then photographs and internet advertising. So it does note here that it's understandable that the seller may be monitoring, right, their property with security devices, okay? The last paragraph here says the seller is advised to post a notice disclosing the existence of those security devices. People need to know that they're being recorded or monitored, okay? It also notes that we as the broker are not responsible for the loss or damage to personal, real property, or people because of the lockbox, okay? Third parties may access, they may take photos and videos, and the seller is urged to take reasonable precautions to safeguard and protect valuables that might be accessible during showings, and they should consider getting insurance to protect against any sort of risks. it notes here that we as the brokerage, we don't have insurance to protect the seller. Okay, we don't maintain insurance to protect our seller for theft, damage, and so on. 14 talks about photographs and internet advertising. It's common, as you know, to get photos, take drone videos, do video walkthroughs, get Matterport, blah, blah, blah. And it talks a little bit about licensing in here. It talks about, understanding that once these images are placed on the internet, we may no longer have control over who can view these images and what use the viewers may make of those images. Okay, so when people come in and take video of that property, it could end up who knows where. Some sellers may have concerns that if there's a video of my home out there on YouTube, that it may show how to break into my home or things of that nature. So we're letting our sellers know, once we send this stuff out, it's no turning back once it's on the internet, right? Let's see here. There's a paragraph regarding key safe and lockbox. The default is that the seller's authorizing us to put a lockbox on the properties. I recommend right now, guys and gals, you use a Supra on every listing. No combination lockboxes. You do not want people going out to your listings without you knowing about it. And when you take a listing, you want to use the CBS code function on your Supra boxes, the call before showing code. That way, anyone that wants to go to the property, even if it's vacant, can't just walk in. They need a code from you first. And that way you can limit the entrance to the property, especially as we think about coronavirus protocol and so on. Okay. By the way, I don't know if you guys knew this, but failing to adhere to showing instructions from the MLS is a fine, a finable offense from the MLS. And guess how much? It's a lot. It's $1,000. It's maybe even $1,500 if you just go to a listing without using the showing instructions. Okay, so be aware. I'm going to do in our office meetings, I'll do a highlight on what the most expensive fines are from the MLS. Okay, we'll keep going here. 16 talks about putting a sign up or not. Then we have our equal housing opportunity and right to reasonable attorney fees paragraphs that we always have. 19 is our additional terms. Here's where we can either add documents or we can add in more verbiage. You notice here I put in here that the RLA-CAA is a part of this agreement, the residential listing agreement and coronavirus addendum or amendment, which we'll look at in a minute. Number 20, management approval, basically says that if you bring me a listing and it's not a good listing or for whatever reason we don't like it, within 5 days we can actually send it back and cancel it. Let's see, 21, successors and assigns. It says this agreement is binding on seller and the seller's successors and assigns. So if they pass away, this agreement is still in effect, okay? 22 is our dispute resolution. Mediation is automatically a part of the agreement. There are a few other additional mediation terms I'm not going to go into right now. And then the entire agreement, basically anything that we've discussed, seller, prior to this is superseded by what is in writing right here. And then 24, ownership, title, and authority. Basically, the seller is stating that they are the owner. Nobody else has title to the property, and the seller has the authority to execute this document, et cetera, et cetera. Very last paragraph that is an option is representative capacity. And what this is by checking this box, it will add a form to your zip forms. And that form is to declare who is the authorized signer of whatever entity is selling the property. Representative capacity. It means that somebody in the trust, the LLC, the corporation, whatever, has the capacity to execute these documents. So you need to get a signature to declare who that person is. Seller signs below and you sign below. And then guess what? You just took a listing. Congratulations, which is fantastic. Okay. So that is our residential listing agreement. Any questions? Now's a good time while I get back to our folder here.
I have a question about what you just said. If there is a listing that's in a trust, so the owner just passed and the 3 children equally are inheriting the property through the trust, would they all three sign as seller, or is that where I would use representative capacity to find out if there's a point person or what? How does that work?
Yep. So that's exactly the situation I'm going through right now. There are 5 successor trustees to this person who's deceased trust. And there are 2 options. One, all 5 have to sign everything,
Okay.
or, and they would sign as representative capacity as successor trustees, because the trust will spell out. It'll say, well, there's 2 things to understand here. There are beneficiaries, and then there's a trustee. The trustee is the person authorized to execute documents on behalf of the trust. There may be many of them, co-trustees. Beneficiaries are the people that get benefits from the sale, right? So you need to see that trust to see maybe there's one person that's the trustee, but all 3 people get benefits, right?
Okay.
In our case, we have an attorney that is drafting documents that allow only one person to sign on behalf of the trust. Basically, it's giving authority from all 5 siblings to one person. That way we don't have to go chase around 5 people all across the country, one of which is in hospice. The other one is Mick Mars, who was the founding guitar player of Motley Crue. He's a little hard to reach, I found out. So we just want him to sign one thing and one thing only, and then
Yeah.
we'll be good to go, right?
Okay.
So no autographs, unfortunately, guys and gals, if anyone's wondering. All right. So great question. Thank you for that. Let's see. We got about 15 minutes. Let's talk about the exclusion. This is your exclusion from the MLS. It's pretty simple. You're going to make it an addendum to the listing agreement. That listing agreement is dated today. We got our seller. We've got our office. Okay. Number 1, it's declaring again who the CRMLS, that is our primary MLS. Number 2, it reiterates the benefits of using the MLS and what would happen if you opt out. Number 3, it talks about the mandatory submission to MLS and the clear cooperation policy. All the things that we have looked at already, okay? And number 4 is our instruction. So if we're gonna exclude the listing from the MLS and put it into registered status, well, we have a few options. 1, don't put the property in the market until blank date. Or 2, do not market the property during the entire listing period. Okay, so those are the 2 options about when the property will go into the MLS or not. Okay, and with that said, paragraph C states here that if either of these 2 are checked, if you are excluding, seller, you must know that if there is any public marketing on that property, it must go in the MLS within 1 business day. Okay, that rule is always there. So that's our exclusion form, real simple. And guess what? I have to sign these. You will send these to me for signatures. Once it's excluded, you then enter it into the MLS as a registered listing. Okay, some of you may be familiar with the old rule where you would actually upload this document to the CRMLS. Now you actually go into the MLS and basically enter it yourself. You know, they just wanted to avoid them having to do all the work. So now you have to do all the work. So since we're on that topic, let's just do a quick recap on the differences in the MLS statuses, okay? So this is our clear cooperation policy. We just talked about registered or waiver or, excluded, off market. Those are all this status, registered. So what can be done? Well, first, no marketing. You may not market the property except to clients of the listing broker. That's the office like we spoke about. When it's registered, it's not displayed in the MLS. Nobody can search for this listing except for the MLS, and I think I can see them as well. No commission offered. Okay, so we're at a point where we can't sell it to an outside company or an outside broker because it's off market. So there's no compensation offered to outside agents at this point. The days on market does not accrue. Your days on market will stay 0 until it goes to the MLS. It does not get distributed to the MLS, like we said, okay? And again, showings to listing broker client only, as we discussed. Now, that's registered what do we got to do for a registered listing? All you do is put in these few pieces of information: the address, the beginning and expiration date, the price, and the day you intended to start marketing as per the exclusion form that you would do. Okay. So next is coming soon. Coming soon is where we're going to start telling people the listing exists. It's going to go in the MLS. There's compensation offered to outside brokers. There's no days on market. It will get distribution, meaning it'll go to all the IDX sites, but there's no showings. No showings. It coming soon means it's coming soon, but it ain't here yet. No showings. Coming soon is limited to 21 days only. At the expiration of 21 days, it's going to flip to active automatically. And then our last one is active, which is what you're all familiar with: full marketing, full showing, days on market accrues, et cetera, et cetera, et cetera. Okay. So I have a question: who would want a listing like this as far as registered? You know, registered means you're securing the listing, but you're just not ready to put it for sale yet. You're just securing the contract, getting your seller to sign and agree. You don't even want to do pre-marketing with the coming soon. You're just taking the listing and you're holding on to it until that thing's ready to go. Coming soon means maybe you're finishing up some last minute things, you're getting some photos taken, your video or whatever you're doing, and then active is full blown for sale. Okay. Over time, you're going to start seeing a whole bunch of different day on market. You know, we already have days on market and cumulative days on market. You're going to see new time frames that are going to be things like days not active, days in the pending status, days listed. So there's going to be a whole bunch of new time frame or clocks that are going to be ticking, and you'll start seeing what some of these numbers look like. We'll see what we do with that information over time. Okay, let's get back to the zip forms and start thinking about wrapping up here. I promised that I would show this guy.
Hey, Nick.
Yes.
Yeah, I have a quick question.
Please.
May I?
Yes.
Okay. So if we're doing flips with an investor, should we require them to sign the registered listing? Would that be recommended?
So you sell them a junker, and they're going to list with you after the fact?
Yes.
I would
after fixing it up, because there is a period, right?
Yeah, you definitely, well, however long it takes to fix it up. Yeah, I would insist on getting a listing agreement signed right then and there.
Mm-hmm.
And then, yes, you would register it and you would exclude it. In a situation like that, I'd probably take a year listing. I would exclude it for, 9 months or 3 months, 6 months, something like that. Because you can always put it on the market sooner, but not later, if that makes sense. So definitely get your agreement signed, because otherwise, people are going to start walking over to that job site and poking around. And if you don't have a listing agreement procured, then it's fair game.
Okay. All right. Thank you.
You bet. Okay, let's look at the single party comp. So this is what we would use for a for sale by owner. I get this question a lot. What do I do? Well, it's similar to a listing agreement. Date prepared, who's the seller, who's the broker, what's the property information, and then compensation, right? With a FSBO, we're always concerned about getting paid. Well, here's where we declare what our compensation is. And just like the other form, we're going to put in, well, I'm going to bring you a buyer directly, FSBO. I'm only going to charge you 4.75%. And that's it, right? And that's and then you can, and this is where you can make it specific, right? If principal accepts an offer from this person within this amount of time. So here's where we would include this with our offer and say, hey, you only have to pay a commission only if this person accepts it during this period of time. Okay, there's a beginning date and an expiration date, kind of like a listing agreement, right? And then there's a section for a lease agreement as well. And then it goes on to just, essentially some of the similar listing information for compensation, assigning the commissions, when there may or may not be compensation due, et cetera, et cetera. But suffice it to say that if you've got a FSBO deal you're working on, the seller you're working with would sign this, and you would use that to get your commission. Now, there is a whole paragraph, just like we've already seen. It's exactly the same about the benefits of using the MLS and the impact of opting out. Now, remember though, differently here, you're not listing the property. You're just creating a compensation agreement with one of the parties. On the second page, paragraph 2, here's where you declare who are you representing in this transaction, okay? Maybe you're only representing the seller. Maybe you're doing a dual agent, but in most FSBO cases, you're doing this. Number 3, broker will act as an agent for the buyer or tenant exclusively in any transaction. Principal agrees and understands that even though we may do some work for them, because we're going to have to get all the paperwork, as you guys can well imagine, that is not to be intended to be a agency agreement. So we're basically going to tell them, hey, I'm not going to represent you. You got to figure out the forms and blah, blah, blah. But you know what? Give me 1% more and I'll represent you as well. And I'll do all the paperwork for you. I always use that as leverage for negotiating to try to get a little more commission because you're going to do the work anyways. So there's your opportunity. Okay. Everything else pretty much exactly the same as in the listing agreement. All the paragraphs are mirror images of the paragraphs we've already seen. And then the last in connection to that is the fair housing and discrimination advisory for the seller to sign. So that is our single party comp. That's what you're going to use for FSBOs. Let's see, a couple more minutes. Let's just do a couple more. Modification of listing. Pretty self-explanatory. It's a one-pager. If you're going to make changes to a listing, you would just note that we're modifying the listing agreement dated blank between Sally Seller and Keller Williams Pacific Estates. And for this address, we're going to change either the price, we're going to change the expiration date, or we're going to change some of the other terms, maybe the compensation, maybe who knows what. Okay, so if you're going to change any terms of the listing agreement, this is the form you use. It's a one-pager. It's pretty simple. Okay. Last but not least, we can't have a contract class without talking about coronavirus. Here we go. Listing agreement, coronavirus, addendum or amendment. You know, I've done classes specifically for the COVID forms. I just wanted to show you, if you think back to the listing agreement review, in the additional terms, I added this as an addendum to the listing agreement. You guys, every listing you take right now needs to have this agreement attached for a lot of reasons. Number 1, it allows us to limit who can see the property. Number 2, it allows the seller to limit specific marketing activities. I don't see a lot of that happening. Number 3, it allows limiting of post acceptance and other sale activities. Again, I don't see a lot of that either. So mostly you can leave these blank unless there's specific circumstances. If they do limit any of the marketing or pre or post sale activities, it just tells them that they may be violating the buyer's rights contractually. They need to talk to an attorney and yada, yada, yada. But what's really important here is that it tells the seller that we have rules for showing and that they are obligated to follow them just like we are. Showing requirements, you know, per the California Department of Public Health. It allows you to shift the burden of the costs for showing and sanitizing to the seller if you want to. I don't see a lot of people doing that, but you can. And then if you need to pull the property off the market, you can use this form to extend the expiration of the listing agreement automatically. Okay. And then what also happens here, they sign the PED-S, where they are making a declaration regarding their health status. I've seen stats recently that say 1 in 4 LA County residents has or currently has or has been infected with COVID-19. 1 out of 4. That's crazy. The news tells us that we are in the most dangerous place in the United States of America right now. So with that said, we better make sure that people are taking this stuff seriously and walk them through what the form says. It's a health declaration. It's saying that you're allowing people to come into your property. Those people may be infected with a harmful disease, and you need to be aware of that. And you're agreeing to also tell us what the status is of your health, that you haven't been infected, you're not been exposed, you don't have any symptoms, et cetera, et cetera. And if you do, you need to tell us and inform us immediately so we can take necessary precautions. This is the PED that the seller will sign. The last part of this is the 2-page BPPP, best practice and prevention plan to prevent the infection of COVID-19 and the spread. And it basically just has all of our rules for showings, cleaning and disinfecting the property, the rules for entry, and the rules for sellers. Okay, I'm not going to go through this form because I've done that on another video. If you need that video, feel free to call, text, email, and I'll get it to you. Ladies and gentlemen, if you are showing properties, if you are taking listings, you need to have this completely memorized, okay? 2 pages of what we're allowed to do as real estate agents right now. The DRE is paying attention. If you have a listing and you don't follow the required protocol and the DRE's out running around because they ain't working, right? They're not at the offices either. They're working from home. So you know what they did? They took a big chunk of the employees and put them out in the field to go look to see if there's anybody violating these requirements. And if you get caught by the DRE not following COVID protocols, trust me when I tell you, the last person you want to hear from is the Department of Real Estate. Okay, you know it's bad enough hearing from me, but the DRE is a whole nother thing. Okay, so with that said, memorize this stuff, guys and gals. Take it seriously. You know, hopefully we get through this stuff sooner than later. But the odds of us loosening our society and restrictions are going down by the day as numbers keep going up with COVID. And what does that do for us as an essential service? Well, it means that right now we can work. If things keep getting worse, there's no reason why they will start restricting other essential services like us, as they've already done for dining, even grocery stores are limited to 50% capacity, et cetera, et cetera. So guys, do the right thing, take it seriously. Read this. If you need help, you all know where to reach me. It's 4 o'clock. I'm done. Anyone have any questions, comments? Now is the time. I'm hearing crickets.
Thanks, Nick.
You are welcome.
Thank you, Nick.
You got it. Hey, Happy New Year's, everybody.
Nick.
I appreciate all
Oh, likewise.
Yep. You
Happy
need
New
to
Year.
Thanks, Nick.
make sure you call me, okay? Don't wing it. Don't make it up. Call me if you need help, all right?
I will be
We
calling.
know we will.
All right, good.
Okay.
Talk
Bye-bye.
soon.